To introduce Chair McFerrin is going to be Ken Gage of the Paul Hastings firm. Ken, can you hear me? Can I turn it over to you?
I can hear you, and welcome everyone. You've stolen my thunder, but I'll still make the introduction here. We're fortunate to have a speaker here today to talk to us about some of the challenges facing the National Labor Relations Board, its relationship with the courts, among other things. And our next speaker has a distinguished career of public service. After graduating from Rice University and Yale Law School, she clerked at the Fifth Circuit for Chief Judge King. A brief stint in private practice was then followed by her service as, among other things, Chief Labor Counsel to the Help Committee of the United States Senate, Senior Labor Counsel to none other than Senator Ted Kennedy, Deputy Director for Senator Tom Harkin. She has been nominated to the board by Presidents Obama and President Trump, and most recently, she was named the chair of the National Labor Relations Board by President Biden. So we welcome Chair Lauren McFerrin here to speak to us today.
Thank you so much for that kind introduction, and thank you all for having me here today. I apologize in advance. I had every intention of being there to speak to the conference in person. I've attended this conference many years and I always enjoyed it. I got caught up in the Amtrak fire on the tracks debacle last night and spent about 5 hours in the Philadelphia train station, which is not enough of the thing I would necessarily recommend. But I ended up ultimately giving up and just coming home, and I appreciate the opportunity to speak with you virtually. So the theme of this conference is challenges and opportunities, and I can certainly speak to the challenges that the board is facing right now. As for opportunities, I can't really discuss the opportunities that the board might have to address significant questions of law, as I'm, as you know, not allowed to discuss pending cases. But I can try to talk a little bit about the impact that some of the work that this board majority has done and what opportunities it might be creating for people seeking to invoke their rights under the National Labor Relations Act. But to start with, like I said, the challenges part is easy. I'd say the two most significant challenges that we are facing as an agency right now are lack of resources and what I would characterize as an evolving relationship with the federal courts. First, in terms of our resources, there is simply no question that there is a huge demand for our agency services right now. In the last fiscal year 2023, the board received 321 unfair labor practice cases, which, as you know, when cases come to the board, that's the last step of a process. That's a minuscule amount of the cases that the agency receives overall. But we received 321 unfair labor practice and representation cases, which was up from 308 cases the year before and a significant increase from the year before that. Yet still, in the first 6 months of this fiscal year, so just in the last 6 months, we've seen an additional dramatic increase in our case intake. Our pending cases are up an additional 30% or more. And we've also seen significant increases in the filing of union election petitions. For the last few years, year after year, the numbers just get higher and higher. Again, just within the last 6 months or so, we've had a 35% increase in the number of election petitions filed with the agency. So that's a good problem to have. People are more aware of their rights and people are exercising them, and people want to make use of our agency services. That's why we're here. But it means that everyone from our regional offices and our mission support staff to our administrative law judges and our board member staffs, everyone at the agency is dealing with a surge in workload. Now, last year, we did get a funding increase from Congress for the first time in almost a decade. That was a $25 million increase that enabled us to avoid furloughs. Furloughing our employees was honestly on the table as of last year. We were able to fill a number of limited IT critical vacancies, do some IT work, and to kind of meet some other non-labor needs and account for non-labor inflation. But we weren't able to really meet the challenges. The regional offices added some staff, but capacity was still far outpaced by our rising caseload. We also hired 6 administrative law judges to help people get more hearing dates for their cases. We received flat funding this year, and while that we should be able to absorb the costs of inflation and the anticipated federal pay increase through attrition and other kind of cost-cutting measures, we simply can't make the kind of significant investment that we need into increasing our staffing levels that we would need to keep pace with our rising caseload. I asked them to run some numbers. Our caseload per staffer is increasing at all levels of the agency, at all phases of the adjudicative process. We are on track this year to have the highest caseload per staffer in more than 25 years. We would like to be processing everyone's cases faster at all stages of the process. We would like to improve the agency's technology systems that I know the public interacts with on a regular basis. We would love to do more outreach and education to make sure that people are aware of their rights and the services we provide. But we are simply drowning, and it's all that we can do to keep up. And interestingly, at least at the board level, and I think this is probably true on the GC side as well, it's not just an issue of volume. We've also seen real changes in the complexity of the cases that we are handling, which adds to the resource challenges. I've been at the board for almost a decade now, and the complexity, and I don't mean to use this term pejoratively, but the litigiousness of the cases that we've seen before us really has been a notable change in the last few years. We're seeing constant streams of special appeals and requests for reconsideration of kind of routine agency decisions at every stage of the process. Decisions like whether to hold a hearing virtually or in person, challenges to subpoenas, disputes about how to produce documents, repeated questioning of well-settled areas of law. These are things we didn't used to see a lot and have become almost routine in litigation before the agency now. A federal judge reviewing a recent action of the board lamented the challenges facing litigants who are tasked with litigating against the limitless resources of the federal government. And I guess with all respect to the court, I would have to take some issue with that characterization. We have entities litigating against our agency in the case of the general counsel, or before the agency in the case of those of us on the board side, that do seem to have limitless resources, and we unfortunately do not. So that's probably the primary challenge that we're facing as an agency. But another one that I really did want to highlight today is what I would characterize, as I said, as our evolving relationship with the federal court system. Now, when you look at the numbers, you wouldn't think there's much of a story to tell here. The board's enforcement rate in the courts of appeals remains relatively steady. I looked back over about the last 5 years or so. It's hovered between kind of 75 and 90%. We do okay, we get a passing grade. Similarly, our success rate in obtaining injunctive relief in 10J matters, I think, has been relatively stable as well. But there's a deeper story to tell here when you look at the relationship between the board and the courts. Now, to be clear, there is certainly an appropriate role for federal courts to play in reviewing the decisions of agencies like ours. Our statute in particular incorporates the opportunity to seek judicial review as part of the process. The federal courts, however, seem to be signaling recently a receptiveness to taking a much harder look at everything that agencies like ours are doing. Now, we've always seen a lot of scrutiny when we try to do things a little outside of our comfort zone, such as our recent forays into the world of notice of comment rulemaking. Essentially, every major rulemaking that we've ever done has been challenged in court, and often with at least some level of success. Two kind of prominent examples would be the notice posting rule that the Obama administration did, under the Obama board did, and the Ring board's decision on election procedures, which encountered some struggles in the courts as well. And of course, there's always been questions where courts have not given us deference in the context of particular adjudications, generally when they're not perceived to be legal questions that the board has particular expertise in, such as contract interpretation questions or things like that. But lately, it feels like it's increasingly common for us to get more searching scrutiny, even in relatively routine adjudications, into areas where the court used to be somewhat reluctant to tread, either based on longstanding precedent giving deference to the agency's expertise in labor policy, or simply out of a lack of desire to kind of get into the weeds of adjudication in a heavily fact-bound manner. They seem to like weeds lately. We've been handled several recent losses in the courts of appeals where the courts simply seemed to have a different view of the facts and decided that there wasn't substantial evidence to support the agency's decision, or that we failed to adequately consider evidence that the court found compelling. If there's two ways to look at the evidence and the reviewing court doesn't like the way the board majority saw things, they seem more inclined lately to simply go with their own assessment of the facts rather than the agency's. And we didn't used to see courts having the appetite to do that quite as frequently. I'll just give one example. One example that really kind of stands out for me is a recent decision of the Eighth Circuit in a case called Strategic Technologies. Now, the board in that case had found that the respondent violated both 8A3 and 8A1 of the National Labor Relations Act with a mass discharge and discipline of employees soon after learning of their interest in unionization and union activity. I'll do a quick overview of the facts here because I think it's helpful to understand the context. This case involved a bargaining unit of about 60 maintenance employees. The employer first learned of potential employee interest in unionization during one employee's exit interview on August 30th. A few weeks later, after one incident of failure to follow safety procedures that was quickly resolved, The manager ordered the supervisor to evaluate and rank all the employees in the unit, though no such endeavor had ever been undertaken before. The supervisor later admitted at the hearing that his rankings were randomly determined and that he perceived no discernible differences between the first and last ranked employees. 3 employees with no previous disciplinary history were then fired by the manager in September while the supervisor was on vacation. In early October, some of the workers began meeting with the union and soliciting authorization cards. On October 9th, the manager then terminated an additional 14 employees from the bottom rankings of the supervisor's list, ostensibly for poor performance. Particularly relevant here was the fact that the manager falsified verbal counseling forms to put in the employees' files and actually forged the supervisor's signature on them. Only 2 of the terminated employees had any previous documented performance issues or disciplinary history. The administrative law judge evaluated the evidence and found that the employer's proffered reasons for the mass discharges were a pretext for anti-union discrimination, and that the discharges violated the act. A unanimous bipartisan board agreed with that conclusion. The Eighth Circuit disagreed. While acknowledging its obligation to enforce the board's order when our factual findings are, and I'm going to quote here, supported by substantial evidence on the record as a whole, and its obligation, and I'll quote here again, to defer to reasonable inferences that the board draws in making findings and conclusions, the court nonetheless rejected the board's findings that these discharges were motivated by anti-union animus. The court specifically criticized the board's finding of pretext, stating that it lacked substantial evidence and that instead was based on, quote, suspicion and unreasonable inferences. The court also criticized the board's reliance on the timing of the discharges to support either a finding that the employer had knowledge of the workers' union activity, even though there was direct evidence of that as well, or to support a finding of animus towards that union activity. Finally, the court found that the board had inappropriately relied on the falsified verbal counseling forms, and that the falsification did not undermine the employer's proffered rationale that the terminations were performance-based. Basically, the court just had a completely different view of the facts than the board, and notwithstanding its acknowledged obligation to defer to our reasonable inferences, it wanted the case to come out the other way. Now, that's a particularly stark example, but it's the kind of review that I think is becoming more and more common when our decisions go to the courts of appeals, even in the absence of any changes to the standards of review that would be applicable under Chevron or any other administrative law doctrine. And that's just the level of scrutiny that we're seeing in routine cases on kind of ordinary questions of application of law to fact. Of course, we're also facing challenges on multiple fronts that raise big questions about the nature, the structure, and the function of our agency. The federal courts have signaled, kind of from the top down, that they're open to opportunities, big and small, to question the actions of agencies like ours. And parties are kind of throwing arguments against the wall to see what sticks. The challenges that we are seeing now are sweeping and unprecedented. The major questions doctrine is being raised in decisions that involve fairly routine applications of longstanding board precedents. Challenges to the constitutionality of the board's structure and functions are raised routinely. It's been suggested that the board's administrative law judges are unconstitutionally appointed and unconstitutionally protected from removal, that board members are unconstitutionally protected from removal, that it's unconstitutional for 2 sides of the board to exist that have one has prosecutorial authority and one has adjudicative functions. It's been suggested that we can't award back pay without a trial by jury. Even independent of whatever might be looming with Shemrod and other administrative law issues, and I think it's an open question whether and how much that would directly impact the board itself, it feels a bit like open season on regulatory agencies like ours. And to be clear, it does impact the way we operate as an agency. It changes the way we write and how quickly we can issue decisions. It changes the way we go to court when we have to go to court. It impacts our decision-making about how to address issues in terms of the question of rulemaking versus adjudication. It presents, in the words of the conference theme, a real challenge. Now, I don't want to raise the alarm bells too much or too prematurely here. Obviously, even in a world where we may be facing the challenge of greater scrutiny and less deference from the courts, we do still have opportunities to fulfill the mission of the Act. Perhaps it's not entirely surprising that some of our recent most impactful decisions have been in areas where the board is, at least ostensibly, entitled to the greatest amount of deference, namely our own procedural rules and our approach to remedial issues. So I'll start by talking about procedural matters. Specifically, I'll talk a little bit about the CEMEX decision and the election rule and kind of the opportunities that this has created. I'm going to talk a bit about the decisions, which I think some people might be familiar with, but I want to make sure we all have kind of the same baseline level of knowledge. But then I'm going to focus a little more and talk about the preliminary evidence we have about the impact of these changes. Then I'm going to shift focus and talk a little bit about remedial issues, again, talking through a couple of major decisions and talking through what we know about the impact of those major decisions on the ground. So let's talk about CEMEX and the election rule. The issue that I always think of these, like I said, as kind of two sides of the same coin almost. Providing a timely and fair procedure to determine whether workers want a union or not is obviously a key policy goal of the National Labor Relations Act. So the board last year issued two major decisions, one in the form of a rule and one in the form of an adjudication, that speak to the question of how we provide workers with that fair and efficient process. Now, by way of background, as everyone here is probably aware, historically there have been two primary ways for a union to become recognized for purposes of collective bargaining. Either voluntary recognition, where the workers approach the employer with evidence of majority support and the employer agrees to voluntarily recognize and bargain with the union, or through the filing of a petition, which was traditionally involves a 30% showing of interest by the union, and then the board conducts an election. The election process has historically been used much more than voluntary recognition. And I think in a perfect world, elections might be the preferred way to determine what workers want, but there are a number of challenges that get in the way of workers' free choice. And when that happens, the election process can actually undermine the goals of the act rather than serve them. The first problem is delay. Delays in the election process create kind of a cascade of problems. There can be turnover in the workforce. There can be disputes about voter eligibility and other complications. Historically, probably the biggest problem with delay is that it provides opportunities for unfair labor practices like threats, coercion, or the firing of union supporters. They can taint the election environment. After a significant effort by the board or during the Obama administration to address these delays, the Trump board changed the rules that govern the election process for the first time in history, extending the amount of time it takes to go through the election process from filing to petition to certification. Now, by changing these timetables for both pre-election processes and post-election challenges, it created significant delays in the process that did not seem to serve the goals of the act. That rule got tied up in court for a long time, but now those challenges are largely resolved, and this board has issued new rules that return to the more efficient election process that was in place during the Obama administration. The new rules, which became effective last December 26th, tighten the timetables for union elections to take place and reduce unnecessary litigation at various stages of the process that can cause delays. The board is attempting to vindicate workers' rights more quickly, and if the union were to win, get parties to the bargaining table faster in service of the goals of the act. Are these new rules achieving their goals? Well, preliminary data, while very preliminary, is promising. Since the new procedures took effect in December, first I should explain, actually, there's two types of elections that we have at the board, for those who aren't familiar, or two paths that you can have to getting an election. One is a stipulated election, where the parties get together and agree to the election process and what will take place and how it will run. And the other, we call that a stip. And the other is a contested election, where the parties can't come to an agreement on how the election should run and take place. You have a hearing, you go through a fair amount of process in order to figure out how the election is going to proceed. So since the new procedures took effect in December, the median time from petition filing to election in a contested election has been cut almost in half. Before the rules took effect in fiscal year 2023, that median time was about 105 days. Even in a contested election, that's been brought down to about 59 days since the rule took effect. The initial data also shows that prompt elections are becoming increasingly the norm when you look at both stipulated and contested elections as well. It's not entirely surprising, I guess, when you change the default rules for how something will work when you don't come to an agreement, you often change the kinds of agreements that people will come to. So now if you look at both stipulated and contested elections, more than 40% of elections go from filing to tallying of votes within 30 days. Before these rules went into effect, that was true for only about 13% of elections. So removing unnecessary delays from the process is a really important step this majority believes to achieving the Act's goals. But there's a second problem that has really hampered our ability to provide workers with a fair process for determining they want representation, and that's election misconduct. The election process does not effectuate the goals of the act if it's tainted by misconduct, like threats, retaliation, or the firing of union supporters. Elections that take place in an environment of intimidation are not an accurate reflection of true employee sentiment. Moreover, we as a board aren't serving our congressional mandate if we can't provide a fair election process. Now, there's always been a path to challenge election misconduct through the election objections process, but the system that the board had in place was often ineffective. Up until now, if you had an election process underway and there were unfair labor practices that the board determined were serious enough that they could have impacted the outcome of the elections, in most circumstances, the board would simply order a rerun election. So the workers would demand recognition. The employer would refuse to recognize the union. The workers would file for an election and go through what was then a lengthy election process. If the workers faced coercion or unfair labor practices or intimidation, they would then go through the process of bringing charges and litigating them before the board. And then, if they're lucky, the whole process starts all over again. That wasn't the free and fair representation process that workers are entitled to under our law. The rerun election could be years later, the bargaining unit might have turned over, or unfair labor practices might have made workers reluctant to pursue representation. The workers who knew what they wanted at the beginning of the process never got a fair chance to demonstrate that. The board would sometimes find a bargaining order to be an appropriate remedy in cases involving very serious employer unfair labor practices, under the standard articulated by the Supreme Court in a case called Gissel. But these bargaining orders would issue only in very narrow circumstances, where the board determined that a free and fair rerun election, even years later, would not be possible. And sometimes, even if the board found that those conditions were met, the orders were unenforceable in the courts. So that really wasn't providing an effective solution as well. The board's CEMEX decision articulated a new framework for addressing the effects of election misconduct that is more consistent than the current majority believes with the goals of the act. It is probably the most significant decision that I've been a part of during my 9+ years at the board. The CEMEX decision supports elections by facilitating a fair election environment that discourages employers from violating workers' rights and encourages them to provide a fair election process. I'll explain how it works. Under CEMEX, when workers seek recognition for their chosen representative with a showing of majority support, and to be clear, they have to have a showing of majority support to be in kind of CEMEX world here, the employer now has 2 weeks to respond in one of 3 ways. Option 1, the employer could recognize the union voluntarily. That's the smoothest path forward. The workers have shown they have majority support, they get their union, they start bargaining. Option 2, the employer refuses to recognize the union, but must file a petition for an election with the NLRB within 2 weeks. Now, the employer has a right to file an election, that's in the statute. If the election proceeds in a fair environment with new rules in place to make sure that it's efficient and no unfair labor practices are committed that would impact the outcome of the election, I would maintain that's another best case scenario. The workers have had a quick and a fair opportunity to determine if they want a union or not. However, if the employer insists on an election and then taints the election environment by committing unfair labor practices that the board finds would have potentially impacted the outcome of that election, the employer doesn't get another bite at the apple. Instead of ordering a new election, we now turn to the other evidence we have of employee sentiment, which is the authorization cards that supported the initial showing of interest, and we issue a bargaining order based on those cards. The employer had its chance to have an election, but it doesn't get a second chance after demonstrating by its own misconduct that it can't maintain a fair election environment. Of course, there's an option 3, where the employer is presented with a demand for recognition and does nothing. It does not agree to recognize the union. It does not file for an election. In that case, the union would file an unfair labor practice charge with the board, alleging an unfair refusal to bargain. And the board would rely on authorization cards as the only available evidence it has of employee sentiment and issue a bargaining order after determining things like the appropriateness of the unit and jurisdiction and questions like that. Why is this a better system? Well, in the current majority's view, this new framework will both effectuate employees' right to bargain through representatives of their own choosing and improve the fairness and integrity of the board's election process. It's consistent with both the language of the act, it respects all the words of the act, and also serves the goals of the statute to promptly resolve questions about union representation in order to avoid labor disputes. Now, what is the impact of CEMEX on the ground? We don't really know for sure yet, in the sense that the board itself has not issued a CEMEX bargaining order yet. I think there's numerous administrative law judges that have, but that question has not kind of trickled its way up to the board. There has certainly been, and I don't have the numbers handy in front of me, a significant increase in the number of employer-filed election petitions. I think it's something like And the entire year before CEMEX went into effect, we had, like 30 some employer filed petitions. And in just the first 6 months of this fiscal year alone, I think there've been, 300 plus. So we've seen a significant increase in the number of employer filed petitions for elections in response to the CEMEX decision. Interestingly, without a corresponding decrease in the number of union filed petitions. There's actually certain advantages to the union to filing for the petition, even in a post CEMEX world. There's advantages to being a certified union rather than a recognized union, for example. So we're just seeing an overall tremendous increase in the volume of petitions, but certainly an increase post CEMEX in the volume of employer filed petitions. So that's one area where this board has done a lot of work. Another area that has been a lot of focus of this board's attention, where I say we've tried to provide opportunities on the ground for workers to vindicate their rights, is with the board's remedial powers. The board's remedial powers are compensatory, not punitive under our statute. That's the way the act works. We can't fine people and things like that. But this board has taken important steps to ensure that we are more thoughtfully using our full remedial authority to address the effects of unfair labor practices. We've looked at remedial issues more closely in a variety of cases, but most notable is probably our decision from December 2022 in a case called Thrive, which addresses the nature of the board's job in awarding a make-whole remedy to victims of unfair labor practices. In Thrive, the majority found that it was appropriate to require that the respondent, who in that case had committed numerous unfair labor practices, to compensate affected employees for, and I'll quote the decision here, all direct or foreseeable pecuniary harms incurred as a result of the unfair labor practices. We explained that in addition to the loss of earnings and benefits, victims of unfair labor practices can incur significant other financial costs, such as out-of-pocket medical expenses, credit card debt, or other costs that are a direct and foreseeable result of the unfair labor practices. Accordingly, we determined that compensation for those losses should be part of the standard and normal make-whole remedy for labor law violations, and that it was appropriate to apply the standard retroactively to all pending cases. Our other kind of significant remedial case of the last few years was a case called Noah's Ark, which articulated a broad array of remedies that are available that are intended to address the chilling effect that repeated or egregious violations of the Act can have on workers' ability to exercise their rights under the law. Employers who commit repeated or egregious violations of the Act will now be more consistently required to do things like distribute to workers an explanation of their rights under the Act, read the notice of violation out loud to workers, mail that notice to workers so they can read the notice in the privacy of their own home, allow representatives of the board to visit the workplace to ensure compliance with the remedial requirements of the Act, or reimbursing a union for bargaining expenses in failure to bargain situations. These kinds of remedies attempt to address an employer that has shown a resistance to unionization by providing a safer environment for workers to exercise their rights. So what impact has the board's work in the remedial area had? Interestingly, the best source of information that we have about the impact of Thrive and other decisions right now is probably found in settlements, primarily because settlements more specifically list the type of remedies being secured, and they're obtained relatively quickly. Whereas board decisions applying Thrive, when we apply Thrive in a board decision, we leave the question of how you calculate and figure out what is part of all direct and foreseeable pecuniary harms, for example, we leave that question to the compliance proceedings. It can ultimately come back to the board if there's a challenge to those compliance proceedings, but that takes a while. And again, we have not seen kind of compliance challenges to what's been ordered under Thrive trickle their way back to the board. So this is all anecdotal, but since the board has issued Thrive, we have seen, kind of the kinds of things that are being negotiated and agreed to in settlements. And again, with Thrive being the default rule, we think that there's some notion that it's changing what people are agreeing to in settlements. When you change the default rule, you change what people will agree to again. So obviously, victims of unfair labor practices who lose pay often need to find money from other sources, for example. So we've seen the award of things like loan interest, credit card interest, the awarding of fees and penalties for early withdrawals from retirement accounts. Similarly, sometimes people who lose income can't pay their bills. So we've seen compensation for like late fees on mortgages or auto loans, or phone and utility bills, property taxes, overdraft fees from bank accounts, or even eviction costs. Workers who are unlawfully terminated lose benefits and can face expenses like health insurance premium increases or increased out-of-pocket medical expenses. So we've seen settlements awarding compensation for these kinds of expenses. Similarly, we've seen the restoration of benefits like tuition reimbursement, retirement contributions, or paid leave that may have been lost during a period of time when someone was out of work. Someone who loses their job unfairly typically has to try to find a new one. So we've seen settlements providing for search for work expenses, resume printage, resume printing, mileage, that kind of thing. Compensation for the additional expenses that are incurred as a result of a new job, such as added commuting expenses, the cost of a new uniform, the cost of additional childcare expenses, or even the cost of relocation. We've seen settlements providing for reimbursement of immigration application fees or the cost of a flight out of the country when someone's job loss causes the loss of a visa. And it's my understanding that we've even had a few settlements providing for compensation for mental health related expenses incurred as a result of job loss. Now, I want to be super clear on this. These are settlements. It's unclear how many of these forms of compensation would have been awarded after a board decision in a compliance proceeding pursuant to Thrive. And it's also clear that many of these forms of compensation might well have been part of a settlement prior to Thrive. But nonetheless, it's interesting to look at kind of the post-Thrive settlements and see what types of remedies are being contemplated during a process where the law requires that respondents that have have been victims of unfair labor practice or committed unfair labor practices compensate affected employees for all direct or foreseeable pecuniary harms incurred as a result of the unfair labor practices. So again, those two areas, the area of kind of remedial authority and the area of our own election procedures and processes, are areas where this board has done a lot of work to try to create opportunities for people to take advantage of the protections of the Act, exercise their rights under the Act. That was about all that I had prepared to say today. So I'm happy to spend the rest of the time answering whatever questions people might want to ask. I can see you all in a little kind of box in the corner of my screen there. And again, with the understanding that I can't talk about issues that are currently pending before the board or issues that are likely to come before the board, I'm happy to discuss whatever you all might want to talk about. Perhaps people are just enjoying eating their lunches, which is totally fair too.
Hi, I'm Matt Bodie. I'm at the University of Minnesota Law School. And I asked a labor law question just this past semester, and all my students have taken it. So I think I could ask you this because I'm not sure what the answer is. But so in my hypothetical, there was a union presents a majority of cards for a particular unit, but then the employer says that's not the right unit. The unit you want is much bigger. So like 60 versus 300 employees. So they have, let's say 45 cards out of the 60. And the employer says, no, your unit should be 300. Is the employer obligated to file a claim or file a petition with the board? And if so, what unit would they put in terms of the under the CEMEX ruling?
I mean, I think in that situation, one of two things could probably happen. Either the employer would file a petition for the unit that it thinks it's appropriate, and that would become the vehicle to litigate the unit appropriateness issues. Or if the employer chose to do nothing, then the unit appropriateness issues would be litigated in the context of the subsequent unfair labor practice proceeding. That was something that, while not super common, did happen when we used to issue in kind of in the world of GISL bargaining orders. You do have to adjudicate those issues somehow. What's the unit appropriateness, et cetera. And so that our administrative law judges can and do that, and they would do it in the context of the 885 proceeding if the employer chose to kind of do nothing.
Gotcha. Thanks a lot.
You're on.
Lauren, can you hear me?
I can hear you, yes.
Okay. Lauren, this is Vicki Lipnick. I don't know if you can
I
see
thought
me.
that was
so-
you. I can only see you look like a little pink dot, but I thought that was you.
There you go. Yes, I'm wearing my Barbie pink today, so fight the patriarchy. Ladies. This is, as you know, I served at the EEOC, so this topic will not be unfamiliar to you, but I did want to ask you, and I asked this question even last year. There is Section 7 and then there is Title 7, right? And so the Lionel Elastomer's decision, I am told at a number of forums that the EEOC and the NLRB are now working on some joint guidance, right, for employers to know how to square Title 7 and Section 7. And I'm just curious if you can comment on that at all, what the status of such guidance might be, and just generally your thoughts about that case, which of course, as you know, overturned the General Motors case.
In answer to your first question, to the extent that there are efforts going on between the agency and the EEOC to provide guidance. Those are efforts that are and are appropriately, of course, being handled by the general counsel. That's not really the role of the board. So it would be both I am not privy to them, and it would be inappropriate for me to comment on any kind of coordinated enforcement guidance that is being worked on between the general counsel and the EEOC. That's a question for General Counsel Abruzzo. My general take, I'll give you kind of my 30,000-foot answer on when I get questions about the conflicts between EEO law and the NLRA. My first and general answer is that I think the conflicts are generally overstated. Title VII, as I don't have to tell you, former Commissioner Lipnick, is not a general civility code for the American workplace. It prohibits particular types of discriminatory harassing behavior, a severe and pervasive environment of harassment. Generally speaking, when you're looking at the kinds of cases that we're looking at, you're looking at isolated instances of misconduct, an outburst in the context of a discussion about a grievance or something like that. I believe that was the particular context in Lyon Elastomers, in fact. We're not talking about something that creates the kind of severe and pervasive environment of harassment that Title VII is speaking to. So I don't know that you have a lot of, at least like kind of factual overlap between the concerns of the one statute and the things that we're kind of addressing in the other. As to Lyon Elastomers in particular, I think that the question of what loses what kind of protected activity loses the question of the act, it loses the protection of the act. It kind of depends on putting yourself in the mindset of how the act thinks about these things. That protected concerted activity is protected concerted activity. It's something you are lawfully and you have a right under the law to engage in. So the question is not whether the employer, applying its disciplinary practices consistently, would have disciplined that activity and under other circumstances, because that ignores the protected nature of what's going on here. We thought that the question more appropriately, and I think the question more appropriately is, when exercising those rights, did you do something so egregious as to lose the protection of the act? Because otherwise, allowing the employer's even consistently enforced policies to define the scope of the act would be inappropriate. Employers' HR policies don't define the scope of the act's protections. The board defines the scope of the act's protections. And it's to the board, not the employer's policies, to answer the question of what loses the act's protections.
Are there any more questions out there?
Someone else walking. I'm not sure if they're walking to the mic or not.
I think they're just walking.
Okay.
Well, if there are no more questions, I'm going to thank Ken and Chair McFerrin for a heroic talk by Zoom.
My pleasure. Enjoy the rest of your conference, everybody. Thank you very much for having me.